In this video, we'll talk about Pittsburgh medical malpractice cases and Pennsylvania medical malpractice cases and the nuts and bolts from start to finish. So once you believe that you may have a medical malpractice case, the first step is talking to a well-qualified medical malpractice lawyer. And I've talked in other videos on the best ways and best steps to find the best medical malpractice case for your Pittsburgh, Pennsylvania medical malpractice matter. Once you find a lawyer that works with you and they tell you that you've got a case, which again is going to consist of the lawyers investigating the records. Remember, the medical records are the keystone of every medical malpractice case. And no matter how terrible the outcome, no matter how bad things are, there's no case unless it's proven definitively by the medical records themselves. That's the best evidence in the case. So after your lawyer reviews all of the relevant medical records in the case, what they have to do in Pittsburgh, Pennsylvania is then send their summary and send all the medical records out to a medical expert. So in Pennsylvania, you have to get the blessing of an expert, so a medical doctor in the same field or specialty as the doctors or nurses or hospital in question. So if you have a delayed diagnosis of cancer case and you feel that it was, say, your family doctor that was responsible, then your lawyers are responsible for hiring, consulting with, and paying a well-credentialed family medical doctor to review the records to confirm that based on the standard of care that they know it as a practicing doctor, that there was a deviation in standard of care and that doctor gives you what's called a certificate of merit. So in Pennsylvania, the certificate of merit is an absolute requirement and a predicate to filing a valid medical malpractice case in Pennsylvania. If you don't get the okay from a doctor saying, yes, I've looked at the medical records and this is medical malpractice, then you have no case and your lawyers literally by law cannot file a case. And that's because there was a statute put into place in the early 2000s called the MCARE Act. And it has all different sorts of aspects to it, but one of them is a requirement for filing a certificate of merit to demonstrate that the case is meritful. So that's the first steps in the case, is review the records, lawyer believes it's a case, now sends it to a qualified expert, assuming they now believe it's a case, your lawyer will get what's called a certificate of merit. Now the next step is that the lawyers have to prepare a complaint on your behalf. Now as an aside, sometimes, and you should always have this discussion with your lawyer, there is a possibility that your case could be settled before even filing suit. It is not unusual that we settle cases before ever even filing a complaint with the hospitals in question. We sometimes do this with UPMC, we do this with AHN, we do it with outlying hospital systems like Westmoreland and Geisinger. And sometimes the mistake is so clear-cut and the damages are so clear-cut that the hospitals and the insurance companies that defend them are happier just to pay the settlement early on to avoid all the legal costs and the time and expense associated with fully litigating a case out. So the point is, if your lawyer tells you that this is a super clear-cut, a slam-dunk case, so to speak, you should explore the possibility of settling your case way early to avoid all the stress and anxiety and uncertainty and time associated with a full-blown medical malpractice lawsuit. But in the event that that's not a possibility, then the next step in the process is your lawyers prepare a complaint. So they basically list out who the defendants are, who you are, and all of the facts that are entailed in the case that happened to you or a loved one. And then they also put in the allegations of negligence, where they believe, or your lawyer believes, based on what the expert has told them or what the medical science and literature says, that there was a deviation in standard of care. And in certain circumstances, there can be a lot of different ones. There can be different failures at different points in time, all of which either individually or collectively wound up causing harm under the circumstances. So your lawyer prepares the complaint, they send it out to you, you look it over to make sure that the facts are correct, okay? The legal allegations and the negligence component is not necessarily something that you are going to know all that much about. But you have to make sure that the facts are accurate, because you sign off and sign a verification saying, to the best of your knowledge, this is all true and accurate. When your lawyer gets that, they file it and your lawsuit has begun. Now the other side gets served with it, sometimes by a sheriff, sometimes the lawyers on the other side, if they're known to your lawyers, will accept service, and then the defense begins. The insurance company gets involved. There's typically an investigation if there wasn't one done already, and they put together what's called an answer to the complaint. Sometimes you'll find that people on the other side file what are called preliminary objections, meaning they had an issue with something in the complaint and they need some court intervention to either try to knock out some of your allegations or ask for additional clarity if they feel that what has been contained in the complaint is not specific enough. But once you get past the preliminary objections, the next step is that the defendants answer the complaint. So they basically send back this boilerplate list of denials and their own specific defenses to the case. And then there's another sort of formulaic response that we do, again, in response to the answer, called a reply to new matter. And that's what's called the close of pleadings. So all the written legal paperwork at the beginning is done. And now you move into the real meat of the case, and that's called the discovery process. And the discovery process entails written discovery, so we send interrogatories and requests for production of documents, and in some cases we send the defense what are called requests for admissions. But the idea being that we now have an opportunity by law to send written questions and written requests to get all the information and data and evidence that we need to build our case. On the other hand, the defense does that to us as well, and you're going to have to answer a whole lot of questions and produce documents depending on the types of claims in your case. For instance, if you're making an economic loss claim, say you were injured and it caused you not to be able to work, or a loved one died who was a breadwinner in the family, and there's going to be a claim for lost income in the future, you're going to have to provide things like tax returns and pay stubs and things of that nature. And it can be cumbersome and burdensome, but unfortunately that's just part of the process in supporting your claims in the case. The defense is entitled to know that as well. Now, a side point here is that in our experience, the discovery process is more often than not a huge battle. Typically, the first responses that we get from most hospitals, most doctors, are woefully insufficient. And in my estimation, that's typically done as a tactic, because they figure that most lawyers on the plaintiff side are either lazy or not going to work hard enough, or they're too busy with other cases to really follow up on that and not get the evidence that is out there. And so it takes time for us to go file motions to the court, forcing the courts to compel the defendants to produce all the key information. And I find the best information that you get that is best supportive of your case, separate from the medical records, always comes from those court battles, getting the court involved, putting the defendant's feet to the fire, so to speak. So that takes time, though. And the discovery process in general takes a lot of time, so you have to prepare yourself for that. If you're in a medical malpractice case in Pittsburgh or Pennsylvania in general, and it's going to go the distance down to trial, you got to anticipate at least a year's worth of discovery, because what happens is we serve a set of requests. The defense has at least 30 days to respond. They typically don't. We have to follow up as a professional courtesy. If we don't get what we want, then we have to file a motion. Then there are specific times that the defense has to respond to that. Then you're at a bit of the mercy of the court in regards to them scheduling it, and so on and so forth. And it just takes a lot of time. And then you also have to factor in that there are what are called depositions that occur. And the depositions are when the lawyers get to speak to the parties in question. So if I'm handling a medical malpractice case, I am taking the doctor's depositions, I'm taking witnesses to the events in question, whether it's nurses or other personnel that were there. We may have to take depositions of subsequent treaters, so doctors that saw the patient later on who can talk about damages or how the damages were caused by what happened earlier on. And also the defendants are going to be taking your deposition and other witness family depositions, or depositions of people that would support claims for damages in the case. And again, this all takes a lot of time, because typically scheduling. So if you can imagine, if you have a case where there's more than one defendant, each of them has their own lawyer. So now you're dealing with the schedule of not only the witness or the defendant doctor or nurse or hospital representative, but you're also dealing with the schedule of all the lawyers on the other side. And I can just tell you that this is oftentimes a headache that takes a long time to get something scheduled that typically only takes 3 hours, but it can take 3 months sometimes to get scheduled, and it can be really frustrating. And unfortunately, it's just part of the process. So now let's take it out. We've completed all the discovery. You're maybe a year and a half out from the time that your lawyer first told you that you had a case and you filed a complaint. What happens next is called the production of expert reports. So at the end of the case, the way that it works in Pennsylvania is that the experts that each side is consulted. So the doctors, they hire their own experts to defend their care. We hire doctors to explain what the standard of care was, or we hire nursing experts to show what the standard of care was, how it was deviated, and what was caused as a result. Each side has to produce written reports from their experts. So your lawyer will take all the information that's been developed in the case, so all the key evidence, all the deposition transcripts, all the medical records, and send it to the experts. The experts then review that, synthesize it, and come up with a report. Now that they know all of the evidence, they know all the surrounding factors in addition to the medical records that explains what happens, and they write a report. And they say to a reasonable degree of medical certainty that these were deviations of the standard of care. They're basically pointing out the list of ways in which the defendants were negligent. We send those over to the other side, then they have a time to have their experts consider both our expert reports and the records and the evidence, and inevitably, in most instances, they submit their expert reports defending it and saying how it wasn't negligent and it was appropriate and this was just a complication or an unfortunate outcome or whatever the typical defense is going to be. So once the expert reports have been exchanged, the next step is you're getting close to trial. And your lawyers will prepare what's called a pretrial statement. The other side will be preparing their pretrial statement. And this is a big document that kind of summarizes the case and goes to the court, gets filed. And it's sort of a summary to the court explaining to the judge what your claims are about, what you believe this case is about, why you should win, what your evidence is, listing all your different witnesses, listing your experts, listing the key documents, giving a description of the case. And once those documents get filed, the court, and it differs from county to county within Pennsylvania, but in Allegheny County, the court then schedules what's called a pretrial conference, or you might also hear it called a conciliation. And this is an opportunity for, first, the judge to hear about the case, to learn about the case, but also at times to try to settle the case, to see if there's an interest. So they want to find out, well, plaintiff, what are you trying to settle for? What is your demand for settlement? And then they turn to the defense. Well, are you interested in settling this case? First off, do you admit fault, or are you giving consent to settle? And secondly, are you anywhere in the ballpark of what the plaintiffs are looking for, or are we going to need to try this case to a jury and let them decide? Now, one key point here. In Pennsylvania, and it may be the case in other states, but definitely in Pittsburgh, Pennsylvania, and other counties in Pennsylvania, the doctors have special malpractice insurance agreements. They're different than, say, what you and I would have for our auto insurance. And the difference is that most of the doctor insurance agreements have a clause that allows the doctor to decide themselves whether to settle the claim. And that can become a real imposition in cases, because maybe the insurance company on the side realizes that they're in trouble and this is a case that should settle, but you have a stubborn doctor, or maybe the doctor is concerned about the effects of the settlement on their reporting to what's called the national data bank and how that could reflect negatively on them at further down the line at their hospital or other hospitals, that sort of thing. There's a million different reasons. Maybe they're proud, maybe they just believe that they didn't do anything wrong, can't come to grips with having made a mistake. But if the doctor is not giving consent, then there's an impossibility of settlement, unless sometimes there are hospital systems who will pay the settlement through a different fund. They'll pay it from an insurance fund that is there to insure the hospital, and because maybe the doctor was an agent, the hospital may be able to do it. But the point is that if the doctor in question is being difficult and does not want to settle the case, then your chances of going to trial are very high at that point. So now, assuming you've gone through the conciliation or that pretrial conference and the judge is not able to reach a settlement, you are going to get a trial date scheduled. And this is going to involve a lot of hard work by your lawyer and a lot of hard work by you. You're going to have to plan to set aside time to attend the trial, but more importantly, you're going to have to set aside time and effort to practice your testimony, to get better at testimony, to go to the court with your lawyer ahead of time, to familiarize yourself with what it's like, what it's going to feel like, working on your testimony, understanding the documents, understanding the case. It's really critical that you have a good understanding of what the theories are, why the mistakes caused the outcome, and then lining that up with what your memory of the case, what your testimony of the case is going to be. And it's very time consuming. And I find that the people that I represent that work hardest in preparing for trial typically have the best outcomes. And those that maybe don't want to be bothered, or it's just too much time, or it's too much of a hassle, then, unfortunately that can sometimes reflect on the outcome too. So it's not just the hard work of your lawyer, but it's the hard work of you and other critical witnesses or family members in the case also. So then finally the court schedules the trial date, and you get to your trial date. And your lawyer's going to have coordinated the experts on your side and when they're going to come and testify. Are they going to come in and testify live to the jury? Are they going to testify via pre-recorded videotape depositions? Your lawyer's going to be figuring out which witnesses are going to be called when you need people. Different witnesses are going to need to be subpoenaed to attend, and basically get all the cast of characters for this sort of performance or play that is a jury trial organized and in line, so everything goes smoothly, so that the lawyer can tell your story to the jury in the most persuasive and interesting way possible. Now, practically speaking, once the day of trial starts, you start with picking a jury. So, and I should actually take a step back. Again, in most instances, the judge, just before trial, because this is the time when everybody's feeling the most pressure, the judges typically try to give settlement another shot. And I've settled many, many cases just before the case was about to try. So that's always a possibility as well. And understand that your case could conceivably settle at any point in time during this process. There's not a set time. It's just that there are certain times that seem to be more common when cases do get resolved if they're going to. But say the case cannot be settled, the judge can't get it settled just before, the next step is that the lawyers are typically going to work out the pretrial motion. So each side typically maybe has a belief that there's certain evidence or facts or ideas or concepts that shouldn't come into the trial for one evidentiary reason or another. Well, they duke that out and argue that out with the judge, and the judge makes decisions on what can and can't come in to the trial. After those issues are sorted out, then there's jury selection. And this is where the lawyers go, and you can attend this. And it's probably a good idea a lot of times for you to attend it, because your input on who might be good or bad for your case is just as important as your lawyers. And this is an opportunity where the court brings in, sometimes 20, 30, 40, 50, 60 different people that have been called for jury duty, and there's interviews done. And what they're trying to do is get down to a number of people, typically 24 potential jurors, from which the lawyers then can select out of that group who they don't want. And ultimately, what the jury selection process is trying to do is trying to get even-handed people, people that are not leaning too much for the defense, people that are not too anti or leaning towards the plaintiff. So that's the middle ground. A lot of people think you're looking for, well, I want a juror that favors our side. Well, really, I believe that in order for it to be fair, you want jurors that just have an open mind to both sides. That's the best situation. But in any case, ultimately, you get down to 12 jurors. That's the number of jurors in Pittsburgh and Pennsylvania medical malpractice cases that are going to decide the case. And typically, if you're going to have a longer trial, there's going to be alternate jurors, one or two, so in case one of the main jurors got ill, there'd be somebody to fill in for them. And once a jury is selected, then pretty shortly after that, the judge brings the jury in, brings everybody into the courtroom, and it's almost go time. And the matter usually starts with the judge giving general instructions about how the trial will go, at the outset. And then once the judge has completed that, they turn to the plaintiff lawyer and say, are you ready for opening statement? You say, absolutely, get up. And your lawyer gives an opening statement and lays out the case and explains what the defense arguments are going to be and why those are not applicable under the circumstances or are not good defenses, and sits down and gives the jury a preview of what you're going to prove and why you should win. When they sit down, the defense lawyer gets up, and this can be a really difficult time for medical malpractice plaintiffs, is hearing really difficult things that the defense says. Sometimes they say nasty stuff about you, or they say nasty stuff about your loved one that was injured or died, and it can be very, very difficult, but you got to be tough. You have to be strong and trust in the process. After the opening statements are done, then it's testimony. This is when your lawyer is going to put on your case, okay? So it's putting on, getting in, admitting all the key evidence, the key medical records, calling the key witnesses, the experts to testify about why there was negligence, why it caused harm, and then calling witnesses to establish the extent of harm, to demonstrate and explain to the jury why they should award what they should award. Now, one little side point in Pennsylvania that a lot of people don't know is that we are not allowed to, plaintiffs' lawyers are not allowed to request a specific amount of money for pain and suffering, loss of the enjoyment of the pleasures of life, disfigurement, all of the things that are called, quote, non-economic damages. So while we can say, you know, there's a life care plan, there's a medical care plan that's $2.7 million, or, you know, there's a claim that's established for $272,000 of lost earnings. While we can talk about those hard numbers, we are not allowed to tell the jury that for all the pain, for all the suffering, for the embarrassment, the inconvenience, the humiliation, that you should award whatever amount of money. We're not allowed to do that. And so the jurors have to kind of come up with that on their own. And quite honestly, that's probably a strike against us on the plaintiff, on the patient side, because jurors oftentimes wonder, well, how am I supposed to figure out, how am I supposed to put a dollar number on what this person has experienced? And good lawyers find ways, compelling ways, to help the jury understand how to think about that, how to equate the losses of the case experienced by the plaintiffs or the patient and compare that to other things of value. Sometimes can be a very helpful way of doing that. And it's not precise and it's not exact, but it's the best system that we have under the circumstances. After your lawyer puts in your whole case and rests, typically you'll see the defense get up, you know, Your Honor, we'd like to move for a little motion, and the jury's excused, and pretty much always, and it's more a procedural issue, it's more for appeal purposes, the other side moves for what's called a non-suit, saying, we don't think that the plaintiff proved their case. Judge, you can decide to dismiss the case at this point as a matter of law. 99.9% of the time that motion is denied because there were experts testifying that there was absolutely a mistake made here. And so there's a fact issue for the jury to decide. At that point, and again, this is going over the course of days, sometimes weeks this takes to get to that point, then the defendants have the opportunity to put on their case and call their witnesses and explain to the jury why they aren't at fault, why they didn't do anything wrong, or if they did do something wrong, it wasn't the cause of the injuries, or even if they did make a mistake and it caused some injuries, it didn't cause the amount of injuries that the plaintiffs or the patient is claiming in the case. After they put their cases in, then you go to closing arguments, and that's when each side gets up and says why they should win, and on the plaintiff's side, how much they should win for, and the defense argues why they shouldn't be found responsible. And practically speaking, in Pennsylvania, in Pittsburgh, in Allegheny County at least, there may be some counties in Pennsylvania that are slightly different, but I think most are this way. The defense goes first in closing, and then the plaintiff goes last. So the good thing is, in the case on a whole, we get the first word in opening statement and we get the last word in closing. And once that's done, the trial's still not over at this point, the judge now instructs the jury on what the law is, which is a little contrary to what you would think. You'd think that they would read the law at the beginning to the jury so that the jury knows what they should be looking for and how to compare the evidence to the law. But in Allegheny County, at least, the law is not read until the very end. It's called jury instructions, and it can take a long time, but it's critically important because that's the jury's instructions on how you're to think about and decide the case. Describes what medical negligence is, what the standard of care is, talks about what medical causation of harm is, and then talks about the different categories of damages that the plaintiff is entitled to recover for if there's negligence and there's causation. So once that's done, then the judge sends the jury off to deliberate. And that's the final part of the process, at least as far as the trial is concerned. And the jury goes in and they gather around a table and typically get lunch or breakfast ordered for them, and they reason together. They go through, and there's a million different ways that juries come up with the verdicts that they do. Sometimes they take a vote. Sometimes somebody sort of takes the lead from the beginning. Now, there's always a foreperson. There's always sort of the leader that has to kind of run the deliberations, and they're the person that has to sign off on the verdict at the end of the day. And they're given this piece of paper. It's called the verdict slip. And that's where all the key questions are listed. Was the defendant negligent? Was the defendant's negligence a factual cause of the harm in this case? And if you checked yes to the first two questions, then what is the amount of damages that you find is the result of the negligence in the case? And then they enter that. Now, understanding if the jury checks no at the first question, that the doctor or defendant wasn't, case is over. It's a defense verdict. If they check yes to the first question but no as to causation, case is over, defense verdict. So the plaintiffs, us patients, and the people that fight for the patients, gotta get over all these hurdles. There's a lot there, and if you get to it, sometimes the verdicts are not what is right or fair under the circumstances. Sometimes they're more. Sometimes it is reasonable. Sometimes but again, what's reasonable is kind of in the eye of the beholder. And depending on how the verdict comes down, so eventually the deliberation concludes, the jury has reached a majority decision, which in Pennsylvania is typically 10 out of the 12 people have reached a consensus on all the different questions, meaning there can be two people that are diametrically opposed to the answers of the group, and it doesn't matter. As long as there's 10 out of 12, then that's good for a jury verdict. Then they notify the court staff, the judges notify, the parties come back in, and this is one of the most dramatic parts of the case. The jury is marched back in, and the foreperson has to read the verdict. Sometimes the foreperson does it, sometimes the judge does it. It really depends on what that particular judge's practice is. And they say who won, and if the plaintiff won, how much did they win? And if the defense won, that's it. And after that, then you get into the possibility of appeals and that sort of thing, which is maybe for another discussion. But that's the basic process of a medical malpractice in Pittsburgh, medical malpractice case in Pittsburgh, Pennsylvania, from start to finish, as far as all the different steps if you take a case from intake, acceptance, all the way through jury verdict. So I hope that was helpful. My name is Brendan Lupitan. If you have any questions, you can always give me a call or check out our website at myersmedmal.com. Thanks.